5 seconds to go. Start. It appears that having come to know of the judgment and decree passed by the High Court allowing the appeal, the appellant BDA filed a suit being OS number 2070 of 2013 before the City Civil Court, Bangalore, seeking a declaration that the lease agreement between respondent number 1 herein decree holder and respondent number 2 herein judgment debtor void agreement of lease dated 16th August 1999 in respect of the suit schedule property is null and void, and also prayed for permanent injunction to restrain respondent number 1 herein original landowner decree holder from executing the decree passed. BDA also filed two applications under Order 21, Rule 97, read with Section 151 CPC in the execution proceedings for impediment and for deferring the execution proceedings till disposal of suit filed by it. The aforesaid two applications filed by BDA came to be rejected by the executing court wide common order dated 29th January 2015 mainly on the ground that there was no material on record to show that pursuant to the acquisition the BDA had taken possession of the said land, and therefore the BDA cannot obstruct or object to the execution of the decree passed by the competent court. Feeling aggrieved and dissatisfied with the common order passed by the executing court rejecting the applications filed by BDA under Order 21, Rule 97, read with Rule 101 CPC, the obstructor BDA filed two writ petitions before the High Court, being writ petition. By the impugned judgment and order, the High Court has dismissed the aforesaid two writ petitions. Hence, the present appeals are at the instance of the obstructor BDA. Learned Counsel, appearing on behalf of the appellant BDA, has vehemently submitted that while rejecting the applications filed by BDA to implead BDA in the execution petition as obstructor, both the High Court as well as the learned executing court have misread and misinterpreted Order 21, Rule 97, read with Rule 101 CPC. It is submitted that for raising the objection to the decree which is sought to be executed, the obstructor need not be in possession, and it is enough that the obstructor claims title with respect to the said property. Though in the present case, it is the case of BDA that possession was handed over by government to BDA engineering section. It is submitted that in the present case, as such, the property land in question has already been acquired by BDA, and even the award was also declared way back on 12th June 1981, and even according to BDA, the possession of the land in question was already taken over and was handed over to the engineering section. Stop.